Distinguished representative of Sri Lanka.
Thank you, Madam Chair, for giving me the floor. Madam Chair, I will be remiss in my obligations if I was not to congratulate the craftsman of this draft, who has been bold enough to engage in a very onerous task of capturing in a document the important features of the crimes against humanity, about which there is so much of fluidity. What we need to bear in mind is that it is a good working draft that has to be nourished and molded over a period of time into one that is perfect as it could be, having regard to the growing body of contemporary international law. Madam Chair, in considering the definitions of crime against humanity, I thought we need to give some thought to the process of attributing conduct which labels someone hostis generis humanis, meaning enemies of humanity, for the reason that this classification gives rise to the question of whether it is of substantive character substantive character, and it reflects the evil the criminal inflicts. The expression hostis, as we will see, is substantive and not jurisdictional, say the academics. Therefore, it gives rise to perhaps ambiguity. Now, the first ambiguity that's pointed out is that we identify is whether the expression is substantive or jurisdictional, as I said, as a concept. The academics seem to suggest that the word enemy is war talk. It's not law that talks. They say that the expression of crime is law that talks. The third possibility, they say, is that such hostis is to be treated as neither adversary nor criminal, and therefore is not entitled to the rights of belligerents or criminal defendants. Then if that is the case, what then are they entitled to? Is it punishment or is it extermination? So we are warned that any existing political group that claims to speak in the name of humanity would be acting in a manner repugnant to all tenets of law by denying its enemies the quality of being human. We must take that warning to heart. Academia is of the view that in the final analysis, we are getting closer towards what Cicero meant, a universal or cosmopolitan community. Madam Chair, the enemy of all humanity is someone who assaults our nature as political beings through tyrannical and cruel conduct, now, which is worth calling him to account. Now, universal jurisdiction, therefore, does not rest on the hostage location outside the territorial jurisdiction of states. Establishing such a jurisdiction is what we are engaged in now. It is one in which we simultaneously establish a practice of accountability and create norms against radical evil to which anyone, including heads of state, may be held to account. The academics put it very succinctly when they say that it is a call to the enemy of all humanity to account before humane law, using humane procedures to reclaim him for humanity and to affirm humanity in the teeth of extreme evil. Permit me now to turn to Articles 2, 3, and 4 of the draft, the contents of which we are somewhat familiar. We have a definition which is not exhaustive. We have general obligations, which I would say is a stark reminder of what most of us choose to ignore, and obligations to prevent such crimes which we choose to walk away from. The draftsman, having realized this, chose to put it down, obviously, in black and white. I would commend to the drafting committee most respectfully that we visit also the definition of extermination in Article A to B, for the reason, now this is no more than a thought, that the definition which is inclusive is couched in language which is far too wide in my respectful submission. It appears to be inconsistent with the maxim of eusdem generis, as the activity contemplated in the inclusive environment does not appear to be of the same generic character. It would appear that what had been contemplated was a situation perhaps of a blockade or a siege. So therefore, it might be worthy of consideration as to whether the actus reus referred to in the inclusive definition be separated and listed as a separate offense. Now, it is said, Madam Chair, that once the evil of war has been precipitated, nothing remains but the fragile effort to limit the cruelty by which it is conducted. One of the great American scholars, Herbert Wechsler, observed that of these two challenges, no one would deny that the larger offense is the unjustified initiation of a war. This, I say, has a comparable focus on the crime of aggression in the present day on international criminal law, an unjustified initiation which should be considered a supreme crime. But we appear to be obsessed with, however, accountability. We are obsessed with genocide, which has now taken over the environment. Aggression per se appears to be excluded, per se. There is no direct reference to aggression, although in the Rome Statute that is one of the features. We cannot miss the transaction from aggression to atrocity. I therefore commend we consider the inclusion of something in the nature of aggression as a crime against humanity. We must accept the fact that the prevention of war is one of the principal objectives of international law as enshrined in our Charter. Finally, in Article A 2.1.3, I observe a proviso leaving room for broader definitions that may be found elsewhere. Now, where that is going to be is anybody's guess. While this, on the one hand, gives us flexibility, it also leaves room for arbitrariness. We have to make the law clear, easily understood, and predictable if we are to ensure easy, efficient, affordable access to the laws governing the prevention of crimes against humanity and the rule of law. I must, however, finally thank the ILC for setting the groundwork for an all-encompassing convention. I thank you, Madam Chair.
I thank the distinguished representative of Sri Lanka for his statement. I